Okay, good afternoon, folks, from wherever you are. We have a number of people from outside the Yukon and about 40 registered in total. I'd like to welcome you to yet another creation of the Continuing Professional Development Committee of the Law Society of Yukon. Today's presentation is called Providing Legal Guidance to Newcomers in Yukon, the intersection of immigration law and other areas of practice. And our presenter is Amna Bahati, who's probably well known already to some of you. My name is Tom Elliott. I'm a 40-year member of the Yukon Law Society, and I'm your moderator today. As I mentioned, Amna Bahati is our presenter, and just a few housekeeping things, one substantive thing, and a few housekeeping things before I turn it over to Amna. I would like to acknowledge where we are, where this presentation is being hosted from the offices of the Law Society of Yukon in downtown Whitehorse, which of course is situated in the traditional territory of the Kwanlin First Nation and the TKC Conquachin Council. I'd like to provide a little bit of statistical information about Yukon's and in particular Whitehorse's population because it provides context to Amna's presentation today. This information is from the Yukon Bureau of Statistics website. First of all, Whitehorse's population has increased by 30% in the last 10 years. That's a big jump. That's thousands and thousands and thousands of people. And the reason for that is that we continue to have one of Canada's lowest unemployment rates, a very robust labor market that demands that we have people from elsewhere in Canada and elsewhere in the world coming here. And that's exactly what's been happening. Just to drill down in this a little bit further, in the most recent year, September 2024 to September 2023, Whitehorse's population grew by 1,100 people. That's a 3.2% increase. Yukon Bureau of Statistics predicts that the current population of Yukon, which is about 47,000, just over 47,000 people. The Bureau of Statistics estimates that our population for Yukon will be 50,000 people by 2028, 55,000 people by 2033, and 60,000 people by 2038. So we have had a growing population for quite some time, and according to the Bureau of Stats, it's going to continue. And most of that population is going to come into the Whitehorse area to satisfy our growing labor market. So we have hundreds of immigrants coming to Whitehorse every single year. And it's certainly created for a number of years now, a whole new area of practice. Now, before I turn it over to Amna, I'd like to draw your attention to the email that you all would have received from Lynn Piggage of the Law Society last month. It sets out that this presentation is to go until 2 o'clock today, 2 o'clock Yukon time. The purpose of it is to show how immigration law intersects with employment law, criminal law, family law, and also to identify and address the legal issues that immigrants face in Yukon, immigrants and refugees face in the Yukon. Now, Amna's bio is in that same email that you would have received from the Law Society. I'll give you some of the highlights. Amna is at least trilingual, and She has a very interesting background. Most recently, she came to Yukon in 2020. She has an immigration law practice. She did her articling with a boutique law firm in downtown Toronto, where she was trained in the areas of family law, refugee, and immigration law. She also did an internship with the Ontario Attorney General, and she was worked with the Yukon Human Rights Commission until last year. That's just some of the highlights. You can read more of that for yourselves. And I think at this point, we will, I will turn it over to Amna. There will be a Q&A period near the end of this presentation, and Amna will, of course, let you know whether she will entertain questions during the course of her presentation. So Amna, please take it away.
Thank you so much, Tom, for that introduction and for moderating this presentation. Hi, everyone. I'm just going to share the slides now. In the middle of the presentation, I have certain parts where I am asking questions of the audience here. So please feel free to jump in the comment section and write your answers, or you can just unmute yourself and just say what your thoughts are. And I would like to leave your questions to the end of the presentation, just because multitasking is not my forte. So yeah, and then we can get to the questions at the end. But please feel free to answer, to the questions that I will be posing you during the presentation. So as Tom said, my name is Amna. I am very glad to be here. And the topic of the presentation today is providing legal guidance to newcomers in the Yukon, the intersection of immigration law and other areas of practice. I just want to note that the information in this presentation is up to date at the time of the presentation, but as you may or may not be aware, immigration law and policies change all the time. So if you have specific questions at a later date, I would encourage you to check the policies by IRCC or contact an immigration lawyer. And this presentation might, some information in here might be out of date at a future time. And of course, this presentation is not legal advice. This is for public information only and for general reference. And the presentation is divided into three parts. We'll talk about employment law first, and then family, and then criminal at the end. I would like to take a break for 5 minutes after the employment law section, so that will be more or less halfway through, and we can just take a 5-minute break and then come back for the family and criminal law section. So employment law and immigration. Let's start with what an employment lawyer or a labor lawyer would ask their clients who are immigrants in the Yukon. So here are some questions that you should be asking the clients that are coming to you who are immigrants or who are temporary foreign workers. So what is their status in Canada? Does that status expire? So for instance, if you're a worker or a student, your status could expire, but if you are a citizen or a permanent resident, your status may not expire. And when does it expire? And has it expired or close to expiring? So these should be some of the questions that all lawyers can, incorporate into their initial intake forms or when people are consulting with them. Sorry. So I'll go very briefly over the few programs to hire foreign workers and bring foreign workers into the Yukon that the Yukon government has, laid out for us, provided us. And this does not obviously include federal programs. So we'll go very briefly over those, but starting with the Yukon nominee program, it has been more or less closed since May last year. But this year, through an expression of interest avenue, the YNP has allowed certain employers to bring in certain employees that are high in demand or that the Yukon territory wants to bring in. And we're looking at, for this year, we're looking at only 215 foreign nationals being nominated through the program. So the Yukon nominee program requirements are basically that the employer should meet certain requirements, and then the employees that they are bringing in, or the foreign workers that they're bringing in, should meet certain requirements as well. For the employer, they need to be a permanent resident or a citizen. They should be operating an office in the Yukon for at least a year, and they should be registered and or licensed in the territory. And the employer cannot be on the exclusion list, meaning they could not belong to one of the listed areas of practice. So it cannot be a hobby farm or a taxi company or a real estate business. Then other things that that all of us should be aware of is that the employers do have certain responsibilities when they bring in foreign workers. The first one being that they have to show to the government that no Canadian citizen or permanent resident was eligible for the job. So they have to advertise the position. That's the fourth point in this slide, for at least 4 weeks in 3 places, so 3 avenues of advertisement. And they have to show that they made an actual effort to hire a Canadian citizen or permanent resident before looking to hire a foreign worker. They're not allowed to recover costs of advertisement or hiring or retention or the employer compliance fee from the foreign worker that they're hiring. We see in some cases, employers have, especially with the federal program, they have pre-authorized certificates to hire foreign workers. And then they can exploit foreign workers by telling them, if you pay us, let's say, $2,000, then we'll provide your name to the government and bring you to Canada. So that is highly illegal. The employers cannot recover any costs from the foreign workers. They have to pay for the airfare and for the return ticket to the worker's home country if, for instance, the nomination or the permanent resident PR application fails. They also have to ensure that the foreign worker has suitable housing, and they have to help them finding the housing, and they have to also provide healthcare coverage until the foreign worker becomes eligible for territorial coverage. And under this program, the requirement is that you have to hire a full-time employee, paying them at least the median wage level in the Yukon, but they can be short-term or long-term employees. Another option for foreign workers to come to Canada or come to the Yukon specifically, is the entrepreneur program. So the requirements for this program are that they should have a high school diploma at least, and 3 years of entrepreneurial, managerial, and 5 years of work experience relevant to the business. They can open a new business, so start a new business, or they can buy an existing business in the Yukon. And they have to show an intention to live in and manage the business in Yukon, because of course the whole idea is to attract foreign investors to come to the Yukon. They should not have refugee status, so they cannot be refugees, and they cannot have any refusals or denials from IRCC, which is the Immigration and Refugees Department for Canada. They cannot have any refusals from IRCC for any other type of application to immigrate to Canada. They must show a net worth of $500,000 and have liquid assets of $300,000. And like I said, they can either purchase a new business, they can start a new business or purchase an existing one. And it should be in one of the listed areas, such as tech, manufacturing, natural resources, agriculture, tourism, cultural industries, and should not be in the other list of ineligible businesses like retail, restaurants, and other personal and professional services. Now, those were the Yukon programs available to foreign workers coming to the Yukon or investors coming to the Yukon. There are, of course, other avenues available to employers to hire foreign workers. The most common one is the Labor Market Impact Assessment. We call it the LMIA. It is a federal program. It works the same way as I have explained the Yukon nominee program. So basically, the employer has to show the government that they were unable to hire any Canadian citizens or permanent residents for the job, and so they have to look for foreign workers. They must show that they meet all the requirements listed as, employers. They need to make sure that they're paying at least the median wage or the required wage for the type of job that they're hiring the worker for. So, for instance, if someone is being hired in a managerial position, they have to make sure that they meet the wage requirement for that, versus someone in a someone who's in a trades business, or in sort of like a startup job, that the wage would be different for them. So they need to make sure they meet all those requirements. And of course, the foreign worker they are hiring needs to meet the requirements for them as well, that they should meet the minimum education and work experience requirement, the minimum language requirements, and so forth. Sometimes employers who have hired foreign workers under the LMIA program, they are faced with compliance audits by the IRCC. So they cannot be exploiting employees. They cannot be withholding wages or asking them to pay for the LMIA application. And they should not, create a situation of toxic work environment. So there's obviously a power imbalance between a Canadian employer and a foreign worker. And of course, sometimes the foreign workers may not know that they have certain rights in Canada, that they are allowed to leave an employer who is creating a toxic situation for them or who is exploiting them in any way. And the foreign worker may be concerned about their status in Canada, whether they have it, whether they are in the process of getting their permanent residence, whether they have just landed and are faced with a exploitative work environment. So they have options, and we will go over those options as well. But it is important that foreign workers know that they have those rights, and if their employer is not meeting the requirements that they're supposed to be meeting when they hire the foreign worker, or that they have promised IRCC and the government that they will be meeting, that they can be reported. Not all foreign workers are hired under the LMIA program. So some work permits can be issued to foreign workers outside of the LMIAs. So some countries like the US and Mexico, workers can come through the more straightforward open work permit routes to work in Canada, and they may not need the employer to submit an LMIA application for them. LMIA applications are expensive, so the employer has to pay an employer compliance fee, and they have to advertise jobs and all of those, taking care of the foreign worker, paying for their tickets, etc. So it can be prohibitive for some employers to retain foreign workers. It can also, like I mentioned, create opportunities for exploitation. So a lot of the times, foreign workers want to come to Canada through avenues that are LMIA exempt. The LMIAs are also employer specific. So if someone is brought to Canada, comes to Canada under an LMIA application, they cannot leave that employment. They cannot leave the employer or really change the conditions of their employment. For instance, go from full-time to part-time, or even change the job location, things like that. It is not easy to do that without somehow jeopardizing their permanent residence application. But if you come through other avenues, some of which are listed here, you can get an open work permit, which does not tie you to an employer, to a specific employer, and you can work with other employers in Canada. Some job titles do not require LMIA, so this would be like the policy C50 or C51, where a person can come to Canada as a religious worker or a charitable worker without needing an LMIA. So they can work as a pastor with a church in Canada, and the employer will still have to create an employer portfolio with the IRCC. They will still have to pay the employer compliance fee, which is like $250. So it's not very expensive, but of course, those foreign workers are limited to doing those jobs. A lot of the times, Canada also creates, not just federally, but also provinces and territories create certain jobs that are to encourage foreign workers to come to Canada and work in some certain industries. Like right now, the tech workers or anyone in STEM is in high demand. So the processes to come to Canada as a worker to work in that field is easier. Same goes for Francophones, same goes for caregivers. And a while ago, for instance, Ontario had a program to bring in nurses, and Alberta right now has a program to encourage folks to move to rural communities. So you just have to keep your eye on, as an employer, for instance, you have to keep an eye on where you are and what programs are being offered, and you may really not need to go through the LMIA process to hire foreign workers. Then there's CUSMA, which used to be NAFTA, which is a treaty between Canada, US, and Mexico, where it has become easier for workers to mobilize amongst these countries. Then open work permit holders, like I said, if your spouse has come to Canada to study in a master's program or a PhD, for instance, you can then apply to come to Canada on an open work permit, which means you can work with any employer in any job in Canada while your spouse is in that program. Again, these policies change all the time. So it used to be that if your spouse was in any education program, you could come to Canada to work under an open work permit. But now your spouse has to meet certain requirements of studies to be able to do that. So they have to be, for instance, in a master's program at a designated learning institution and get a provincial attestation letter. So all of those conditions need to be met. Same if your spouse is here as a worker, you may be able to apply for an open work permit. And refugees, when their claims have been referred to the RPD, so at the border or later when they've arrived in Canada and they have submitted an online refugee application, they can apply to get an open work permit. And if their family is with them, then their spouse, who will also be a part of their claim, obviously, and their kids, they can all get work permits and study permits. Again, it must, one must remember that work permits expire, whether they're through the LMIA or whether they're an open work permit. So it is very important to keep an eye on, the expiration dates on these documents to make sure that If you have a permit, you also have a visa. So if you leave Canada, you can come back because visas are required to enter Canada and permits tell you what you can and can't do. So you may have a visa to come to Canada as a visitor, but that does not mean that you can work or study. You need a work permit or a study permit to do so. And then intra-company transferees. So if your company is, you're working with a business in the US, that is the company settled in the US or registered in the US for at least a year, is meeting all the other requirements that are required under this stream, and they have opened an office here, you may be able to come to Canada through a work permit as an intra-company transferee, and the company does not need to apply for an LMIA to hire you or to move you to Canada. So this is just an overview. If a foreign worker comes to you, it is beneficial to be able to distinguish between the type of work permit they have. An open work permit, like I said, a spousal sponsorship application, or if your spouse is studying in Canada or under the QAT, you can work for any employer except those who are ineligible. And if you have a closed work permit, employer-specific work permit, which we just saw are LMIAs in a lot of cases, or provincial nominees sometimes, then you are restricted to the employer, how many days you work, hours you work, and where you work is restricted. Of course, this does not mean that you don't have any out from that employer. Sorry, I'll go back to that. So if if your employer has changed locations, if you're working in a different office than what was indicated on your LMIA application, you must notify IRCC. If you are, let's say, nominated under the Ontario nominee program and your PR application is being processed by IRCC, you have to let them know. You have to let the Ontario nominee program office know, and you have to let IRCC know that your location has changed or your working situation has changed. Now, so far, what we have looked at are temporary foreign workers, so workers coming to Canada through work permits. Some skilled workers can enter Canada as permanent residents as well. So, for instance, under the express entry programs, which allow a person to apply for permanent residence directly, one can be, let's say, in Pakistan, and if they meet, the scores, the points that they need to immigrate to Canada under the express entry federal skilled worker program, then they can just land in Canada as a permanent resident. They are given a permanent resident visa. They're issued, once they are in Canada, they're issued a permanent resident card and a SIN number, and then they can look for a job and work with anyone that they like. Before the beginning of this year, Canada, you would be awarded certain points if you had a job offer and employment, an employment ready for you when you arrived in Canada. You would get points, which would make it easier for people to apply for the federal skilled worker option or get permanent residence through other express entry options. Workers no longer get points for a job offer in Canada. So that is, not really a plus point. So if you're meeting the other requirements and you have the points you need to apply for permanent residence under the federal skilled worker, you no longer really need a job offer. You're not given the points for it anyway. And so once you land in Canada, you can find a job that you want to work in. So for employers specifically, it is important to assess their business needs and employee fit carefully to determine which workers should come through which temporary foreign worker or permanent residence programs. So like I've mentioned, You don't always need an LMIA. You don't always need a provincial nominee certificate. Sometimes people can come and work for you under an open work permit. Sometimes you can hire foreign workers who have open work permits. So employers need to carefully assess, are their needs being met through Canadian citizen and permanent resident employees, or do they need to hire foreign workers? Another option for employers is also if someone has applied for a job from another country, let's say Nigeria, and they're highly qualified and they meet all of the requirements of the job, and you've interviewed them and you really like them, you can submit an LMIA application specifically for that foreign worker. And so if all the other requirements are met and your application is approved, you can bring in that specific person. Of course, you still need to advertise the job for 4 weeks. You still need to show to the Canadian government that you did not find a suitable candidate in Canada, so you're hiring someone from outside. But you can do that where that is an option for employers, where you hire foreign workers who you specifically want to hire. In other cases, you can, if you're not finding anyone suitable for the job in Canada, you can apply for an LMIA and get approval through an unnamed application. So you're not specifying a certain person you want to hire, but you have pre-approved LMIA, which is usually valid for 6 months. And then, when folks are applying from outside Canada, you can find the best candidate and bring them to Canada as a worker. Specific occupation permanent resident streams are being created all the time, regionally and federally. So some of them were, in the STEM field, or caregivers, or educators, or people who are francophones who are proficient in French. So it is important that employers look at all of their options. Now let's talk about foreign workers who are working in Canada with their employer, and it is a closed work permit. So they have to specifically work with the employer that that has applied for an application for them, an LMI for them, and they're stuck with that employer. They're stuck with the hours, the wage, the location, all of that. Sometimes, of course, this can create vulnerable situations. This can create situations of exploitation for these workers. And an option for them at that point is the vulnerable worker open permit. So the requirements to be able to apply for this vulnerable open work permit is that either they are being abused or are at risk. Either they're being abused or are at risk of abuse from their current employer. So this permit is a temporary permit, so it does not give you status forever. Usually it is valid for 6 months as well. It has an expiration date. It cannot be renewed. So this permit is a special option for workers who are in situations of exploitation, to get them out of that situation and help them figure out what their next steps are. So usually 6 months is a good time for people to, leave that exploitative situation, leave that toxic employer, and figure out whether they want to apply for permanent residence, whether they want to seek other employment, whether they want to maybe study. Do they want to enroll in a study program and change their status to a student, or if they want to return to their country. So it is an open permit. You can work with anyone you want during this time when you have this permit. You can only apply for it from inside Canada. So if you are with an exploitative employer and you've gone back to your country, you cannot apply for it at that time, because you're not really meeting the essence of this application. You're not really meeting the requirements, which is to get you out of that situation. Like, you've gone back, so you can consider other options to return to Canada if you like. you also cannot apply for this once your status, temporary foreign worker status has expired. So you must have a valid employer-specific work permit, a valid LMIA application that has supported your work permit, for instance. So if your status has expired and for whatever reason you've been working with this employer and you have not, your permanent residence application has not been processed or approved, and you have not changed your status to something else or started working with someone else, you may not be eligible to apply for this open work permit. There is no fees, and it is an online application. And so if you go to apply for this application, they've made it sort of such that someone in an environment of exploitation or in an unsafe environment can navigate it. It is available in many different languages. There's a button on the application where you can, click and it will take you to Google. So it'll exit you from the application. For instance, if you only have internet and a computer at work and you need to submit this application. So they've tried to make it user-friendly. They've tried to make it so people in unsafe situations can access it. And of course, if you are submitting this application, you have to make a case that you are in a vulnerable position. You may need to provide some evidence. There isn't always evidence of, for instance, psychological abuse or emotional abuse. In a lot of cases, there might not even be evidence of financial abuse or other types of physical or sexual abuse. So that is something that IRCC is aware of. And if you have evidence, you should provide it. If you don't, that's okay, as long as you're making a good case for yourself. And this brings the employer to the attention of IRCC, so the employer may be contacted for inspection. I've also seen cases where it has become an exploitative situation and the employer is then reported you to IRCC that, the foreign worker is no longer with us or no longer working with us, and we, no longer want to sponsor his application, or however they want to phrase it, or that you were no longer coming to work, you abandoned your position or whatever. And in that case, it is very important that the employees are made aware that they can still fight that allegation and that it is their legal right that IRCC give them a chance to explain their side of the situation. So in a lot of cases, IRCC will send a procedural fairness letter to the employee to ask them, hey, we are processing your PR application and we have received this letter from your employer who's claiming that you no longer work with them or that you were not a good employee and they don't no longer want to help you with your application. So what's going on? And so for procedural fairness letters, there is usually a deadline, and it is recommended that you seek legal help because lawyers can then use case law and other, supporting evidence that you may have to make a case for you and explain to IRCC that it was actually the other way around, where the employer was abusive, and it is part of their, in a way, exploitation tactic to report the employee to the IRCC, and that the employee is doing everything in their power to find other employment or to find an employer who will help them stay in Canada, So we can make a case for the employee based on the situation. So I'm now at, the question part of this section of the presentation. And please feel free to either unmute yourself and jump in or type an answer in the chat. So my question to you is, a temporary foreign worker comes to you for non-immigration related legal services. What questions would you ask them about their status as a worker in Canada? Yeah, as some of the questions we did go through in the beginning. So you want to ask them basically, what is their status? So what kind of permit or visa are they here with? When does it expire? And ask them questions about their situation. Who are they working with? Is the employer treating them right? How long before they receive an answer for their permanent residence? Are they tied to the employer that they are working with? So all of those things are very, very important.
Obviously, this was a big week for immigration processes and procedure and law with the appointment of a new federal immigration minister, Liana Diab, who will be responsible, obviously, for the Immigration, Refugee, and Protection Act. Two things you should know there. For some of you, you may know that Liana Diab was a long-time MLA in Nova Scotia, where she served both as Attorney General and later as the Minister of Immigration for Nova Scotia. The second thing before we go back to AMNA is I can tell you that the Canadian Bar Association is preparing a lengthy submission to the new federal minister Diab on the act and how it could be changed with recommendations for that change. Okay, with that commercial break, let's turn it over. Let's go back to Amna. Amna, you've got the floor.
Thank you, Tom. So let's dive into family law and immigration now. And I'm going to start with a question this time. What are some reasons that a sponsored spouse may not disclose spousal violence? So we're talking about a person, a foreign national who has been sponsored to come to Canada by their spouse and now are in a situation of violence. What might be some reasons that they are not disclosing to the authorities that they're in a situation of violence or exploitation?
And folks, with Amna's question, I am monitoring the Q&A room. So, and I see there are messages, technical messages from some of you, but in case any of you want to respond to that question, I've got my eye on that.
So I'll give this one more minute and give all of you a chance to just, just throw in your thoughts why you think someone who's been sponsored may not disclose that they're in a situation of violence at the hands of the person who has sponsored them.
Okay, folks, you got 45 seconds left in the Olympics. That's long enough to run the 400 meters. So we'll in less than 30 seconds, we'll go back to Amna. I'm not seeing anything in the Q&A.
Oh, I see something. So Luke has commented, the abusing spouse holds leverage over the abused spouse. Yes. Fear, and Christina says, fear that if the spouse breaks the law, they will both get deported. Peterson says, fear that their sponsor might not continue supporting them financially. And then Susan has commented, worried that the sponsorship will be revoked. And then Noel has commented, impact on children and fear that they will be sent back to the country of origin. That's Lee. And Christina has commented, fear of police in their own country, so they can't trust our police. These are excellent, excellent answers and very valid. Yes. Sometimes folks who have been sponsored, especially by their spouses, to come to Canada, they may be afraid to fully disclose the violence that they're experiencing or the extent of that violence due to fear of losing their status. And the fear might also extend to the person who has sponsored them. Although you need to be a Canadian citizen or a permanent resident to sponsor someone, whether it be a relative like your parents, your children, or your spouse or common law partner. I also want to note that to this presentation, where I'm saying spouse, it also includes common law partners. And, when I say spouse, it does not just mean spouse. So it is important for lawyers and aid workers to keep in mind when they're assisting someone when with leaving their situation of violence. So it not be safe for someone to continue to receive financial support from their sponsor in a situation of violence. Therefore, they may lack sufficient funds to sustain themselves and their family members. And if their status is compromised, they may no longer even have status to work. And they may no longer be able to obtain paying work in Canada. So there's like a chain effect of, you know, if you're reporting your spouse and if it is a situation of violence and you have to leave your spouse, not only are you now not being financially supported, your status might go away, you might not be able to even find work. So it kind of leads you down the road of at least reasonably being scared or fearing that you might not just lose, your relationship, you might not just lose your status, but also the ability to work and earn any money, or have any money or financial means to stay in Canada and live in Canada.
And if I could just interrupt and roll the three final comments on this together, you probably see them from Lenore Morris, Tom Flavin, Lee Kirkpatrick. I wondered if the comments made by them, cultural prohibitions, incorrect information, rejection by the family, are these also issues?
Absolutely. So, um, you know, sometimes people are being sponsored, they want to move to Canada because they want to leave the situation back home. Sometimes there may be cases where even the idea of leaving a spouse, no matter how exploitative or violent, the idea of getting a divorce or the idea of returning to your home country, back to your family after a failed marriage or a failed relationship, might be hugely prohibitive for folks to leave their the person who has sponsored them. So all of those factors absolutely come into play. And um, I'm very glad that everyone participated and that this has started, hopefully getting the wheels turning in your mind about, sponsorship situations. But we'll get into more detail about the impact of all of these steps on the person who has sponsored and on the person who is being sponsored in just 1 minute. So, sponsoring your spouse is one of spouse or common law partner again is one of the more common ways for folks to bring their family or bring their spouse to Canada. Like I said, only a permanent resident or a Canadian citizen can sponsor someone. And once the person has been sponsored, they can apply for a work permit so they can start working in Canada. And, this can happen while their permanent residence application is being processed. So it seems like a straightforward application, but there can be complications depending on whether or not the person who is sponsoring them is in Canada or whether they're outside, whether they have extensive travel plans, or whether the marriage or the ceremony that they had in a country outside of Canada is recognized in Canada as a legitimate, a marriage. So a lot of these things come into play and they can make these things complex. It also, if you have sponsored someone once, you are barred from sponsoring anyone else for 5 years. So there's a bar because, it's just to avoid sort of like a situation where people are, sponsoring a lot of different persons from different places and a lot of different relatives, and then they're unable to support them. So one very important component of being able to sponsor someone to Canada is your financial capability. You need to show to IRCC, to the government, that you will be able to financially take care of the person you are sponsoring. And this is done through an undertaking. The duration of the undertaking is different for the different relationships. So it is 20 years. For dependent children, it is 10 years or until they, you know, become 25 years old, or whichever happens first. So you have to make sure that you are able to financially meet the requirements to be able to bring someone into Canada. The financial requirements are also different. So if you're bringing a child, you might not necessarily need to show that you meet the minimum income requirement. But if you are sponsoring your parent, you do have to show that in the last 3 years you met the necessary minimum income requirement. It also depends on the number of people in your family and the number of people you are bringing in. So there's like a bit of a mathematical calculation there with regards to finances. And again, because the point is that the person who is sponsoring is financially responsible for the person being sponsored, that creates a power imbalance, that creates situations or an environment where the person who has sponsored them can exploit them. So even if a sponsor loses a job or the relationship breaks down while an undertaking is in effect, so the 3 years from the time that the person they've sponsored had gained permanent residence, the sponsor will still be financially responsible. So even if you separate or you get divorced or your relationship has ended or you've lost a job, you are still responsible for the person you have sponsored. So that's one thing. So it is important to know that when folks are, coming to you, family lawyers, or they're talking about not being able to leave the person who has sponsored them because then they'll lose financial support, it is important to know that they have not, because the person who is sponsoring the sponsor is still responsible to support them financially. And that is not just financial support, that means assisting them to be able to live in Canada without becoming, let's say, reliant on social support or the government. That's the whole point of the undertaking, that the government is saying, you can bring in this person, you can sponsor this person to come in Canada, but we have to make sure that they will then not become dependent on the government for anything. So you have to write a contract with us that you will take care of them. That includes clothing, food, shelter, medication, other, financial needs. Anything that they need to do must be met by the person who is sponsored.
And if I could just interrupt, I see Lee Kirkpatrick has asked the question of whether some form of legal marriage is required or will common law suffice?
Yes, so if you meet the test for a common law relationship, that is enough. You don't need to be married. But if you're saying that you are married, then you need to show that you are. If you're saying that, so for someone to qualify to be a common law partner, you have to show, for instance, that you have at least resided together for a year, and that there is, all the signs of a relationship, of an intimate relationship. So you can substantiate that by showing that we have a joint lease together, that we have a joint bank account, our finances are intertwined, that if they are living in back home in a different country, that I have made attempts to visit them or I have visited them and they have visited me. Let's say that we have kids together. You have photographs, messages, emails, all of those things that you may need to show that you are in a relationship. If you're claiming that you are married, so you met the person, you fell in love, you married them, it's only been 6 months. You cannot qualify for a common law relationship, but you can still sponsor them as a spouse, but then you need to show that your relationship and your marriage is valid, right? So it really depends on your situation and what you're claiming while you're sponsoring that person.
And Amna, I don't know if you've seen Noel's question, but Noel Sinclair has asked how CBSA or IRCC, how they enforce the financial commitments by sponsors.
Um, how do they enforce it? So a lot of the times, when you have sponsored someone and their application is being processed or it has been processed already, CBSA and IRCC might not keep track of. So sorry, if the application has already been completed and the person you sponsored, they have already gotten their permanent resident status, they might not be keeping track of it. But if you have fallen back on supporting your spouse, they could report you. Or if you have fallen back on supporting your spouse because you no longer have a job, or you are on social assistance or collecting EI or any of that, then the CBSA or the IRCC might become aware of that, and then they might reach out to you and ask what's going on. If your application is being processed and you've stopped financially supporting the person, and the person who's being sponsored does not report to you, they will most likely not become aware. And that's where the exploitation comes in, right? The CBSA and the IRCC are not very likely or not usually able to keep track of what folks are doing unless another government authority or department gets involved, and then they are brought into the loop. Does that answer your question?
Well, I think that answers Noel's question for sure.
Okay, so sponsors remain financially responsible for the person, even if their situation changes. So some questions that you must ask folks coming to you for other forms of legal advice is this a situation where there is or was an application for spousal sponsorship for PR? What stage is the application at? Is it in the process? Is it finalized? Has the client already obtained PR? If processed, is the undertaking still in effect? So all of those questions become relevant at that point. So a person who has permanent residence cannot lose status or be forced to leave Canada only because they left a situation of violence. So we're starting from the point where how do you leave a situation of violence where you have permanent resident status? And then we'll go on to if you have temporary status, and then if you have no status at all, what happens then? So a person cannot simply cancel the applicant's PR, but what they can do is a sponsor can compromise a person's status, PR status, by telling immigration authorities that the relationship is not genuine, or the sponsorship application was based on false or withheld information. And if IRCC becomes aware of that, this could lead to a loss of permanent resident status due to inadmissibility based on misrepresentation. So you cannot, revoke someone's permanent residence, but if a sponsor, if it's got to that point where the relationship is so damaged, or they just want to, hurt the person they've sponsored, they can tell IRCC that either they withheld information, or the information provided was incorrect, or that the relationship wasn't genuine. And so in that case, again, in most cases, IRCC will reach out to the person who was sponsored and give them an opportunity to provide further information to clarify their case. If they do not, and they revoke your permanent residence, well, then you can always judicially review a decision. So where someone was sponsored by the spouse or partner to come to Canada, they cannot sponsor a new person or partner, a new spouse or partner, until 5 years after the date at which they became a permanent resident, even if they're legally separated or divorced from their sponsor. So there is a 5-year bar to being able to sponsor. This was implemented by, this does not used to be the case always, but this was implemented by IRCC and the government to try to sort of stop a revolving door of sponsoring people to come to Canada. And this was also implemented to try to avoid non-genuine marriages being used for immigration purposes. So, what happens then is that the effect is that 5 years from the date of filing your first sponsorship application, you have to wait 5 years until you can sponsor another person. So if my spouse sponsored me, I also have to wait 5 years before I can sponsor someone else. And same goes for the spouse who sponsored me. So now let's say, how do you leave a situation of violence if you have temporary status? So if a person leaves their sponsor due to a situation of violence and they have not yet received their PR status, but they have temporary status in Canada, so as a worker or a student or a visitor, they can of course remain in Canada. And they have to ensure at all times, as every foreign national in Canada should, that their status does not expire. And it is also important to note that a person cannot work or study without a work or study permit unless there's an exemption. So a visitor cannot work or study. That is illegal. They cannot do that. They have to change their status to be able to do either of those things. And of course, this also means where a person was previously financially dependent on their spouse sponsor, leaving a situation of violence may be harmful to their ability to survive in Canada. So in that case, what do you do? There's an option. We'll go over that. Lastly, a situation where they're leaving a situation of violence and they do not have status. If a person leaves their sponsor due to a situation of violence while their application is being processed, that person will no longer be eligible for permanent resident status. One more thing to note is that the person who is sponsoring can only sort of cancel the sponsorship or withdraw the sponsorship if it has not already started being processed. So if you've provided everything and they have not sent you, the letter that says we are now looking at the completion of your application, or, whatever the first step would be. Until that point, you can withdraw it. But once it started processing, you cannot withdraw it. It will have to be processed. You can, of course, update them, but you cannot withdraw it. So unless the person being sponsored have an existing temporary status, such as worker or student, they will not have any status in Canada and may be forced to leave Canada. So at that point, it is important to explore the possibility of restoration of status. So there is a 90-day limit to do so. So if someone comes to you and they say, I was sponsored by my spouse, they're saying they're going to withdraw the sponsorship application, or they're going to, notify the IRCC that they want to cancel the application, or that it wasn't genuine or whatever. You must ask them, do they have any other temporary status, such as a worker, student, or visitor? And if it is expired, they have 90 days to restore it. After 90 days, they must leave Canada and apply from outside the country. Once the 90 days have passed and you have not had status, it becomes very, very difficult to keep someone in Canada. If a work permit expires, the person must stop working. So one thing also to note is if you are extending your status, let's say as a worker or a student or a visitor, you have what is called maintained or implied status. So you can, in most cases, continue to work, continue to study, continue to, be a visitor in Canada. But if you apply for restoration, meaning your status expired and now it is within the 90 days of expiration and you're applying for a restoration, you do not have maintained status, you need to stop working, you need to stop studying until your restoration application is granted. If it is not granted, you leave Canada. Yes. So now what happens when someone is a victim of family violence? What is their option? So a special permit to stay in Canada and ensure continued immigration status of the applicant while more permanent immigration arrangements are made is to apply for a temporary resident permit, so a TRP, for victims of family violence. In this context, TRPs are intended for cases of family violence from a spouse or common law partner. Family violence is not just physical violence. A person may experience one or more forms of violence, including physical abuse, so forcible confinement, for instance, sexual abuse, including sexual contact without consent, psychological abuse, including threats and intimidation, financial abuse, including fraud and extortion, neglect, consisting of the failure to provide the necessities of life, such as food, clothing, medical care, shelter, etc., and any other way that they could put them in harm, either intentionally or due to omission. So with children, for instance, inadequate supervision or emotional neglect or even educational neglect may apply. And in this case, the foreign national's dependent child or children may also be experiencing or witnessing abuse or neglect. So it is important to also notify the authorities if that is the case. To apply for a TRP for victims of family violence, they have tried to make this process very accessible and, with the understanding that a lot of times, the person being abused is, someone who does not have access to a computer or internet, even their own documents. They might, the person who sponsored them, the abuser, might be withholding their passport or their permits or documents from them. So IRCC is aware of that. This application is processed at specific offices who process applications like these. It is a paper application. You have to mail it in. You do not have to testify against the abuser to get this temporary status. You must, if you can, supply evidence, so police reports or medical doctor notes or whatever you may have to substantiate your case. But again, you may not have anything, and that's fine. Generally, like most TRPs, it is granted for 6 months, but you can request a longer TRP. And at the same time, you can also apply for an open work permit. So this applies for any type of temporary resident permit. If it is granted or valid for more than 6 months, you can apply for an open work permit, meaning you can work with any employer in Canada. And it also does not require any IRCC fees because, again, it is understandable that the person submitting this application may not have financial independence. So one application that often comes up, and a lot of times there's anecdotal evidence or clients hear from other people, is the humanitarian and compassionate application for the really complex cases. So we call it the H&C application. What must be understood is that H&C application is an exception. It is not a pathway. It is not a stream. It is not something that you just apply for to get permanent residence in Canada if you have any other option to be legally in Canada. So H&Cs are the last resort applications. They are expensive. They are hefty. They require research. They require, meeting the test for the H&C application. They require evidence, affidavits, a lot of sort of supporting information because we're asking an immigration officer to use their discretion, or rather we're asking the minister to use their discretion to grant a person permanent residence to stay in Canada because they don't have any other option and they cannot go anywhere else. So for a person in a situation of family violence, they may be able to apply for permanent residence based on H&C grounds. If they do so, they must clearly describe their situation of abuse in a detailed cover letter. They must also mark, so if you're submitting the TRP for family violence or permanent residence application on the basis of H&C grounds, you must always mark the envelope FV to indicate IRCC to process their application quickly and to prioritize it. So you mark it FV because it is a paper application. So this can obviously be a fantastic tool for advocates supporting women who are facing family violence. And, you don't need legal representation to submit these, but it is advisable to make sure that you substantiate your application with as much information as you can provide. A TRP application can also be submitted at the same time as the PR application based on agency ground, but you have to understand that each application serves a different purpose and it is a different process, and you have to pay the fees for the application processing fee for the agency PR application, whereas the TRP or the TRV for family violence does not require a fees to be paid. So another thing to note that is that agency applications can take a very long time to process. And if you are out of status while your agency is being processed, you may be under a removal order. So an active removal order may be issued against you because you're out of status. CBSA will know that you should be removed from Canada, but of course, they will also know that you have an agency being processed. So some of the times, the way to tackle that is you write to the CBSA and ask them to, delay the processing of the removal order because your agency is being processed and you're trying to get status in Canada through a TRP. Yeah, so we get the TRP sometimes, and we let IRCC know that we're applying for agency and we need to have legal status in Canada. The client needs to stay in Canada for these reasons while the agency is being processed. So divorce in some countries can be illegal, extremely difficult. It can take a long amount of time to come into effect, and it may not be recognized in Canada if it was finalized outside the country. So in any event, evidence of a divorce is often required, and not only for family law entitlements, but to regularize status in Canada. So obviously, simultaneously having multiple common law partners or having multiple marriages is illegal in Canada. So it is very important for someone, if they want to sponsor their new common law partner or their spouse, that they have been properly divorced from their previous spouse. And in that case, it is important that they have all the right documents, and anything that needs to, for instance, be translated to English and notarized in Canada to be legitimate has been done. So in a sponsorship application, the person and the applicant, the sponsor and the applicant cannot be the spouse of anyone else. So if evidence of this is found, the sponsorship may be void. Furthermore, if there is no formal divorce, the criminality of a spouse to whom a foreign national is still legally married may make the applicant inadmissible to Canada. So this is the situation even if a couple has been separated for years, have lost track of each other, it can still make entire families inadmissible. So when you're applying to sponsor someone else, or you're applying, for instance, for your own permanent residence, and anyone in your family or in your spouse's family has any inadmissibility issues, that can make you inadmissible. So it is very important to have proper documentation that you are no longer married to that person, or that the person you're sponsoring is no longer married to their prior spouse. Yeah, so there are specific legal steps that can be taken, including in family violence situations, but these must be taken early and quickly to avoid removal from Canada. Now, with regards to spousal and child support, there is significant case law which has acknowledged that the entitlement and duration of both child and spousal support can be directly impacted by the presence of a sponsorship agreement. So courts have taken into account when granting spousal or child support what the undertaking agreement said, how long was it in effect, and someone said, I'm going to sponsor you to come to Canada, I'm going to take care of you, I'm signing an agreement with you and the government to do so, and then the relationship deteriorates and you get separated. What were the entitlements under those under that undertaking. So all of that is taken into account. The courts have given significant consideration to whether the applicant will need to depend on social assistance should spousal support not be granted. When a sponsorship agreement is in effect, it binds the sponsor to provide for the applicant, and the court may see the economic, professional, and personal losses of an applicant in joining their spouse in Canada as a reason to grant spousal support. However, where an applicant has not met their obligation under the sponsorship agreement to make efforts to become self-sufficient, or the marriage is found to be not genuine, or there has been misrepresentation, spousal support may not be granted. So again, if you're a family lawyer representing a client, a foreign national in a matter where you're seeking spousal or child support, all of these immigration considerations need to be taken into account. Okay, so that was family law and immigration. Are there any questions before we dive into criminal law? Okay.
And I see there's a question from Noah. Let me just read it out for everybody. If a lawyer is asked to notarize a foreign document, how do we determine the legitimacy of the original document tendered by the applicant, such as diplomas, visas, etc.? That's the question.
That's a great question. In my experience, I've only ever had to deal with documents that were transcribed by a professional translator from either Canada or the country from which those documents originate. And the person who is, so you can ask the person who is in another country to get their local documents translated and notarized from their country. And then they can provide an affidavit attached to the document that says that these are originals and that they have been notarized and properly transcribed if they're in a different language. So those are the cases that I've dealt with. I've never really had to deal with anything where the legitimacy of the original document may need to be, I would have a reason to question it. Of course, if it is a refugee, for instance, or a situation where someone cannot return to their country or cannot, it is very hard based on the processes in those countries or, how the police system, the police works or how getting a translator would work, situations like that, then you can provide a letter explaining to the IRCC or the CBSA that you and the client have made every effort to ensure that the document is legitimate. And if IRCC has any questions or any issues, that they can reach out to you, and then you can figure something else out. And I
know
can,
there's
I know I answered it in the realm of immigration, but that's all I know right now. So
there's a
I
follow-up question.
Mhm.
There's a follow-up question, Amna, to that. It comes from Peterson Najuli, and he wants to know, perhaps you can see it, that he has heard of instances where a sponsored person resorts to social assistance because of a breach of the sponsorship undertaking. The government can initiate civil collections or even collect the debt from tax rebates of the sponsor. I think the question is that true?
Yes, that is correct. I think Noah's question was, how will IRCC or CBSA, deal with this? And my
Yeah.
response was, if they become aware of it, then they will do everything in their power to collect that money from the person who sponsored. If a person who sponsored loses their job, is no longer able to sponsor, or just withholds finances or goes on social support, the moment they're back on their feet, they will repay that debt to the government. So that undertaking is taken very seriously when it comes to, sponsoring someone and how you're financially responsible for them. So yes, a breach of a sponsorship undertaking can lead to civil collections and the collection of debt from tax rebates. Okay, so we have less than 30 minutes remaining. Let's do criminal law. The first thing to understand is some people are not allowed to come to or remain in Canada, and they're called inadmissible under Canadian immigration law. Inadmissible or inadmissibility is different from ineligibility. A person may be ineligible to apply for a spousal open work permit, does not mean that they're inadmissible. Inadmissibility, the one that we are going to discuss in this presentation, is criminal inadmissibility, but there are different types of inadmissibilities. For instance, medical, financial, misrepresentation, failure to comply with the IRPA, so that's the Immigration Refugees Protection Act, inadmissibility because a family member inadmissible, or safety and security of Canada. So there are many reasons a person can be inadmissible. It is important to know it is different from ineligibility, and we are now going to talk about criminal inadmissibility specifically. So what are the types of criminal inadmissibility? A few factors to note is, are there convictions against a person? Are the offenses committed inside Canada, or are they committed outside Canada? And then you must also note if, you must also note if a person has been charged versus if they have been convicted. So committing a wide variety of crimes, including driving while under the influence of drugs or alcohol, can lead to criminal inadmissibility. Security reasons like threat to Canada or Canadians can lead to inadmissibility. Human or international rights violations, organized crime, like membership in an organization that takes part in organized criminal activity, like people smuggling, money laundering, having a criminally inadmissible family member. All of these factors can lead to criminal inadmissibility. It must also be noted that both permanent residents and temporary residents can be found criminally inadmissible and be removed from Canada or detained. So sometimes, and I've briefly touched on this in family law, but sometimes you can become criminally inadmissible because you have a family member who is criminally inadmissible. So when you're applying for almost any application to Canada, you have to provide information about your family. If it is a permanent residence application, members of your family, whether or not they're accompanying you, will fill all of the relevant documents, all of the relevant forms. And those forms very clearly ask whether or not you have any criminal record, anything that you were charged for, were you pardoned for it, were you discharged from it, have you ever served in the military in your country? And if so, did you witness or take part in a crime committed by the military, by the police? Have you been a government official? Have you, witnessed any crime happen? So those questions are part of almost every application form, and all family members in permanent residence applications or sponsorship applications will have to fill in those forms. And of course, very difficult if you're in another country and you're not providing a police clearance certificate or anything, very difficult for the CBSA or the IRCC to know. But if they become aware of it later on, it can completely jeopardize your status in Canada. So it is very important if clients come to me and they ask me, my father served in the military in South Korea or wherever, and what should I do about that? I always advise them to very clearly and truthfully identify that in the form and explain that your father, while serving, let's say a mandatory military service, did not commit and was not a part of and did not witness any crimes being committed against their country or another country, and et cetera, et cetera. So you try to address it up front and you speak the truth and you let IRCC know that this is relevant to your family member. So that would always be my advice. Like, don't try to hide it. Now my question to you is, what are some questions that you may ask a foreign national or PR holder to determine whether they are criminally inadmissible under the IRPA, which is the Immigration Refugee Protection Act?
Okay, folks, the floor is open. I'm monitoring the Q&A room, and Amna will see if we have any takers as we approach the last 20 minutes of this presentation. Okay, I'm not seeing any, perhaps something will come along, but I'm not seeing anything in the Q&A room at the moment.
Okay, so
Oh,
I'm
there's
looking.
one.
Oh,
There's two. Sue Bogles asked, have you been convicted of any crime? Lenora Morris says, have you ever been convicted of a criminal offense or charged a criminal offense? Another way of the asking a similar question.
yes. So I'm gonna start, speaking more to the topic, and then folks, whatever pops into your head, please type it in. And as I go over the material in the next few slides, more questions might come up to you that you want to ask someone coming to you for advice or representation, and just keep popping them in, and we'll go over them towards the end for sure. So, how do you determine criminal inadmissibility? Well, some questions or some things to consider are being convicted of an offense inside Canada, being convicted of an offense outside Canada that is considered a crime in Canada, and committing an act outside of Canada that is considered a crime in that country and would be punishable in Canada. So how do you figure this out in terms of determining whether someone is criminally inadmissible? Well, foreign convictions and laws are equated to Canadian law through a careful analysis of the foreign law and the Canadian Criminal Code. Let's go over the definitions of serious criminality, and hybrid offenses which are considered indictable under immigration law in Canada. And we will discuss this in more detail as we move on. So serious criminality under Section 36(1) of the IRPA defines a permanent resident or a foreign national as inadmissible on grounds of serious criminality for having been convicted in Canada under an offense which is punishable by a maximum term of imprisonment of at least 10 years, or of an offense under an act of parliament with which a term of imprisonment of more than 6 months has been imposed. Or a permanent resident or foreign national inadmissible on grounds of serious criminality if they have been convicted of an offense outside Canada that, if committed in Canada, would constitute an offense which is punishable by a maximum term of imprisonment of at least 10 years, or committing an act, not convicted of, but committing an act outside Canada that is an offense in that country, and that, if committed in Canada, would constitute an offense under an act of parliament punishable by a maximum term of imprisonment of at least 10 years. So this will determine serious criminality. And important to note here that permanent residents or foreign nationals can both be considered criminally inadmissible if any of these situations apply for them. On the other hand, only applies to foreign nationals. So if anything under Section 36(2) applies to a permanent resident, they may not be considered criminally inadmissible. But if they're a foreign national, so for instance, someone applying for a work permit or a study permit or already in Canada, then this will apply to them. So foreign national is inadmissible on grounds of criminality for having been convicted in Canada of an offense punishable by way of indictment or of two offenses not arising out of a single occurrence. If they have been convicted outside Canada of an offense that, if committed in Canada, constitute an indictable offense, or of two offenses not arising out of a single occurrence that, if committed in Canada, would constitute offenses under an act of Parliament, or committing an act outside Canada that is an offense in the place where it was committed, and that, if committed in Canada, would constitute an indictable offense under an act of Parliament. And then there's hybrid offenses. And hybrid offense, an offense that may be prosecuted either summarily or by way of indictment, is deemed to be an indictable offense, even if it has been prosecuted summarily. So any hybrid offense, even if prosecuted summarily, is deemed an indictable offense for immigration purposes. This means that a foreign national or a permanent resident convicted of a hybrid offense will be considered inadmissible to Canada, regardless of whether the prosecution chose to proceed summarily or by indictment. How does a foreign national or a permanent resident become aware, let's say, that they are under investigation, or that an inadmissibility, a criminal inadmissibility charge is being considered against them? So usually a CBSA officer will write a procedural fairness letter stating that they have inadmissibility concerns, are requesting information pertaining to the situation. So a lot of the times this would pertain to a work permit, study permit, visitor visa application. It would impact every single type of temporary or permanent residence application. And IRCC, who is processing the application, may inform CBSA that there is an admissibility issue, start the process for that. Another thing that a CBSA officer may do is write a Section 44 report. So this is a removal order against you. Once a removal order has been issued against you and you have been informed of it, there are certain things you can do to, ask for a temporary pause of the removal order, or to, request that you respond to that removal order. And we'll go over that as well towards the end of the presentation. So Section 44 report sometimes may trigger an admissibility hearing at the Immigration Division. At the admissibility hearing, the foreign national will be given an opportunity to speak to their inadmissibility concerns, and based on how the decision goes, there may be a removal order issued, or they may be given permission to remain in Canada. So if a person has been found to be inadmissible under 64(1), which was serious criminality, there is no appeal option. So you cannot appeal that decision to the Immigration Appeal Division. Either you are a foreign national or a permanent resident. If you're found to be inadmissible on grounds of security, violating human or international rights, serious criminality, or organized criminality, which means that you can still appeal to the Immigration Appeal Division if you are found to be inadmissible under Section 64(2), but not 64(1), not where there are issues of serious criminality. And of course, this does not bar you from bringing an application to judicially review, a finding of, a removal order against you, or a finding of serious criminality against you, but it takes away your options to appeal to the Immigration Appeal Division. So how do you determine criminal admissibility? Some other things to consider are whether the charges were withdrawn or dismissed. So if the offense occurred in Canada, not inadmissible. If the offense occurred outside Canada, you may be inadmissible if the charges were withdrawn or dismissed. For absolute or conditional discharge, if the offense occurred in Canada, not inadmissible. If the offense occurred outside Canada, may be inadmissible. Pardon granted. If the offense occurred in Canada, you may not be inadmissible if you were pardoned under the Criminal Records Act. If the offense occurred outside Canada, you may still be inadmissible. And again, you might be thinking, how do you deal with it if you are inadmissible? We'll go over that towards the end. So here we are. If you have been found to be inadmissible or there are proceedings of inadmissibility towards you, of course, an option is to respond to the procedural fairness letter. Procedural fairness letter are not always issued. It is more or less up to the immigration officer or the CBSA officer who is reviewing your application to send you an option, to send you a letter asking you to respond. And you should then create really substantial, response if you can, and you're basically given an opportunity to make a case for yourself. Reconsideration request. So if your application has been refused on the basis of serious or general criminality, you can always submit a reconsideration request, meaning it is a letter, it is a discretionary option. It is not a program or a stream or an option under the IRPA or the regulations. This is just something where you're providing, you're requesting the immigration officer who is reviewing your application to reconsider your application, and you're providing additional information and evidence to support that reconsideration. It may be granted, it may not be granted. The immigration officer is under no obligation to even respond to it. Sometimes they don't respond to it. Sometimes they take a long time to respond to it. So you have to weigh your options carefully. Then there's sentencing considerations, and I'm sure lawyers who practice criminal law in the audience, they may have a better understanding of this than I do, but you can always, work with an immigration and a criminal lawyer. They can work together to figure out how do you get sentencing for a foreign national such that it does not meet, the minimum threshold. So, when we were looking at the definition of criminality and serious criminality, it did provide us with an upper and lower limit of what would, define it. So if someone is being convicted in Canada of an offense and the minimum requirement is at least 6 months, after which, if the sentence is longer than 6 months, they are found criminally admissible. What can you do to get them a sentence that is less than 6 months? Maybe 2 5-month sentences, or, if there are 2 different offenses, can be considered 2 5-month sentences rather than one that is longer than 6 months. So you have to work together to figure that out. I have never had the chance to work on something like this, so I can't really speak to the logistics of how that would work, but this is definitely something where lawyers should work together to make sure that the foreign national, their interest is protected, and that their immigration status is not impacted by the criminal code or by the criminal charges against them.
And I wondered if you wanted to go to questions now with 8 minutes remaining. I see Lee Kirkpatrick has asked a question about the procedural fairness letters, and she'd like to know to whom should they be addressed to?
Oh, so a procedural fairness letter, so we would call it a response to a procedural fairness letter. They will be addressed to the immigration officer or the CBA officer. So rehabilitation. So it is an application. You use this application if you want to come to Canada, but are inadmissible because of past criminal activity. You can apply for rehabilitation if at least 5 years have passed since you finished your criminal sentence. And that again depends on what kind of, how you were convicted. So if it has been more than 10 years since the offense, you may be deemed rehabilitated. If it has been more than 5 years, you can apply for rehabilitation. But this applies to criminality and hybrid offenses. This might not, the timing of rehabilitation, whether it's deemed or whether you apply for it, will change based on whether you were found inadmissible under criminality or serious criminality. So that is important. Again, temporary resident permits, we have looked at some, a few types of specific permits that are provided to folks in Canada, just to keep them in Canada while they're dealing with other important things like an abusive employer or an abusive spouse. But temporary resident permits can also be applied. For instance, if you have been considered, let's say you misrepresented in your permanent resident application, it was found that you were misrepresented, and you were issued a 5-year ban to enter Canada. You can apply for a TRP if you have serious reasons to come to Canada, to visit Canada, or if you have serious reasons to stay in Canada. For instance, if your HNC application is being processed. So if someone has a parent or a relative, or they're getting married, or someone has passed away, or someone's really sick, and you just want to come to Canada to visit them, and then you will leave, you apply for a temporary resident permit. Again, for some of the option, for criminality, you have the option to appeal the officer's decision or the immigration division's decision at where you were determined at an admissibility hearing that you were inadmissible and that you were removed. This is not an option for serious criminality. Detention.
And I'd like to know, with 5 minutes to go, are there other slides you'd like to highlight for our participants? Because we're coming up 2 o'clock, and I think that we're going to lose some of our participants.
No, this is the last one, and then I just have a conclusion slide. This is the last one. So I'm just going to quickly go over these options, the last 4. So once you have been detained, you must get a review hearing in 48 hours. This is most of the times when foreign nationals will reach out to either a criminal lawyer or an immigration lawyer. They have the right to receive notice of the hearing and copies of all of the documents that CBSA is using as evidence. At that time, at a detention hearing, you can, provide, let's say, a performance bond or a guarantee, submit a deposit saying that this person should be let go and that they're not a flight risk and all of those reasons. If you are staying in detention after the first 48 hours, your next review hearing is in 7 days, and then in 30 days, and then every 30 days you get a hearing, and you can provide fresh evidence in support of your client between that time, at the hearing, at any time. Pre-removal risk assessment is a request by the CBSA and IRCC. You cannot initiate this application. You can write to an officer to be requested to provide a pre-removal risk assessment, but this is basically where someone is at the risk of being removed from Canada, and you want to tell CBSA that if you are removed, you will face certain risks in your country of origin. So that's the case. You're making a case for removal, to not be removed. Again, you have the option for judicially reviewing at the federal court, and you can always leave Canada and reapply for other forms of other streams or programs. Just one thing to note, sometimes there's a bar for reapplication on other applications, usually like a 5-year bar. So you must be cognizant of that. If you are under a 5-year bar, it is very, very hard, if not impossible, to bring you to Canada. You have to wait out the 5 years. And that is it. I am sorry, I was sort of rushing through the last part, but I hope it was still, informative. Some takeaways from this presentation would be to identify immigration issues early. So when you have clients coming in, include questions about their immigration status on the outset, so you become aware of whether any immigration factors are relevant, and reach out to an immigration lawyer, and we have to work together because it is very hard to keep track of each area of law and how they intersect, and immigration law changes all the time. Immigration policies change all the time.
In the Q&A room, we're not going to have time to get to the final questions, but anybody who does want to follow up with you, I see Tom Flav and Lee Kirkpatrick both have comments. What's the best way for them to contact you? Is it simply through your website?
Yeah, or you can just write me an email. My email address is right under here, abhatti@ab-legal.ca, or you can give me a call and I would love to answer your questions or do some research if I don't know the answer, and I can send them to you in writing.
Okay, well, I'd like to thank you on behalf of the Law Society very much for the presentation today. There's a lot there, and I'll be surprised if you don't have some follow-up questions from our today's participants. I'd like to thank the Continuing Professional Development Committee for yet another great presentation. I'd like to thank the Law Society Yukon for administrative support, and in particular, Lynn Pigage. And don't forget that this is just one in a series of presentations. The next CPD coming up is Thursday, June 12th, with Darren Lees, longtime Whitehorse and British Columbia lawyer. He will be presenting on the UFA 101, which, as we all know, this has become such foundational information for all lawyers practicing, well, certainly in Yukon, if not Canada, as foundational as the courses we all took at law school, especially first year law. So thank you again, Amna, and thank you to everybody who attended. And I hope you have a good day and a good rest of your week.